I work a lot on judges and litigation and how certain cases go to certain courts. My co-author and I, we were following all the cases, all the patent cases that are filed all over the country. And we noticed a big group of cases were filed in a small courthouse in Waco, Texas. We were looking to investigate this, and at the same time we were investigating it, we were at a conference, and a federal judge showed up at that conference, and he pitched the Waco courtroom as a good place to bring patent litigation. And within a couple of years, over 1,000 patent cases alone were filed in this one courthouse before this one judge. And so we've done a lot of work about why that happens, how that happens, why he's interested in these cases. But now we're really looking at beyond the patent sphere. It's really a topic that has a lot of impact in a lot of different areas. So we're looking at the abortion cases, some government cases, or hot button political issues. Those are the cases we're really interested in. And this idea of judge shopping, choosing your judge, is one of the things that we think is something that can be attacked in this process. One of the things we're interested in is why judges would be interested in attracting cases to them. Why they want to get 1,000 patent cases, for example. Why should a litigant that's challenging the abortion laws in a state, or challenging Obamacare, or challenging any number of things, be able to select which judge is going to decide that case? We don't think they should. So we have a lot of proposals to change that, to stop that, to tamp down on that judge shopping that's occurring. This is going beyond patent law. It's been in bankruptcy for many years. It has happened in bankruptcy before patent law. Judges sought these bankruptcy cases to their courtroom in the same way that patent judges now are seeking these cases into their courtroom. There's a lot of potential for this to spread. And we've already seen it spread with the really high, hot button political issues like abortion. The abortion case was filed again in Texas, a small town in Texas, which just has one judge in the division. So they could choose their judge. And who did they choose? Well, they chose a judge who is, before going on the bench, was an anti-abortion lawyer. And there's nothing wrong with that. But we don't think you should be able to choose your judge based on what their proclivities are. We think the randomization of judge assignment is a good thing, something that's part of the system, and something that should be encouraged. Why should we care about this? Well, if you have any interest in abortion, prison reform, healthcare, many constitutional issues will be tried before a judge who has been selected among them 700 judges in the United States to decide that case. Why they've been selected? Well, we surmise that often it will be because the judge has shown by his prior rulings or her previous life experience that she is likely to decide for the plaintiff. We don't think that's a good thing. Judicial system is all about fairness. It should be all about finding the most neutral arbiter of disputes. And so if you care all about litigation, patent law aside, we think our work is really interesting now.